5 seconds to go. Start. This position has been recognized and approved by both the TSERC and the APTEL under the 2013 regulations. There are two types of licenses. First, those who apply for a distribution license under regulations 2D and 12, and secondly, those already deemed licensees seeking recognition of their status as such under regulations 2H and 13. The appellant belongs to the latter category. Regulation 12 of the 2013 regulations applies to general applicants seeking a distribution license, mandating compliance with both the 2005 rules and the procedures prescribed in regulations 4 to 11. It cannot apply to a deemed licensee under regulation 13. The TSERC's finding, as approved by the APTEL, that the 2005 rules are inbuilt into the 2013 regulations and therefore have to be satisfied by the appellant because of implied application of regulation 12 to deemed licenses is contrary to the provisions of the Electricity Act and the very scheme of the 2013 regulations. APTEL erred by agreeing with the TSERC's reasoning that the requirement to infuse Rs 26.90 crore in equity was imposed on the appellant under Section 16 of the Electricity Act, despite recognizing the appellant as a deemed distribution licensee. Conditions under Section 16, whether general or specific, must be specified by the appropriate commission through regulations according to Section 262 of the Electricity Act. Resting on the aforesaid submissions, Learned Senior Counsel urged this court to allow the appeal and set aside the orders of the TSERC and the APTEL to the extent requiring the appellant to comply with the conditions stipulated in Rule 3 of the 2005 rules and infuse additional capital to gain the status of a deemed licensee. Per contra, Mr. Vaidyanathan, Learned Senior Counsel, appearing for the second respondent, Southern Power Distribution Company of Telangana Limited, joined by Mr. Gode, Learned Counsel, appearing for respondent number 1, TSERC, supported the impugned judgment and order and advanced the following submissions. No doubt the appellant, a SEZ developer, may be granted the status of a deemed licensee. However, the 2005 rules and the 2013 regulations will be applicable to the appellant as per the law laid down by this court in Sesa Sterlite Limited versus Odisha Electricity Regulatory Commission and others. The appellant cannot be deemed to be a distribution licensee on its own without making an application under Regulation 13. There is a necessity to harmoniously interpret the SEZ Act and the Electricity Act to uphold the provisions of both enactments. The appellant cannot argue that the 2005 rules and the 2013 regulations do not apply to it being a SEZ developer. TSERC is empowered to impose general and specific conditions at its discretion. The purpose of requiring the appellant to infuse an additional capital under the 2005 rules was to assess the creditworthiness of the appellant as it had accumulated losses at the end of the financial year 2013-14 and more than 50% of its net worth has been wiped out, a fact which is reflected from the statutory auditor's report. No case for interference having been set up by the appellant, Learned Counsel for respondents prayed for dismissal of the appeal. Before proceeding further, it is imperative to refer to certain statutory provisions. Section 14 of the Electricity Act deals with the grant of a license. The appropriate commission may, on an application made to it under Section 15, grant a license to any person to transmit electricity as a transmission licensee, or to distribute electricity as a distribution licensee, or to undertake trading in electricity as an electricity trader in any area as may be specified in the license. Stop.